So the next item of business is consideration of one new petition, and as previously agreed by the committee, will take evidence from the petitioner. The petition is PE1504 by Kathie McleanToremar on party litigants, civil appeals to the Supreme Court. Members have a note by the clerk, the spice briefing on the petition. Could I welcome the petitioner and Gordon McLean to the meeting? And could I invite Ms Mclean-Toremar to make a short presentation of around 5 minutes to set the context for the petition, after which I'll start with some questions and then I'll ask my colleagues to ask some additional.
Good morning, ladies and gentlemen. I hope you understand that this petition is not just about me, but a gross imbalance in the law regarding all persons in Scotland who find themselves in the position of a party litigant, i.e. someone who has to represent themselves in court. And we are lucky enough to live in a democratic society where this is possible. In paragraph 1.8 of appeals from the Court of Session, Scotland to the Supreme Court, it states, as I have said in my petition, that although at the moment permission to appeal does not require an interlocutor from the inner house at the Court of Session, but the appeal must be signed by 2 Scottish counsel, and this is where the flaw is. A party litigant, as we all know, is a person who represents themselves. This can be for whatever reason, maybe lack of funds for a solicitor, but more so nowadays, lack of funding for solicitors from the Legal Aid Board. Having seen for myself the solicitors demonstrating about this issue, so we will have a situation where more and more people will be forced to represent themselves in the court. When a party litigant represents themselves in the Court of Session and loses their case, then appeals and loses that. I might add there are no statistics as to how many party litigants have ever won a case in the Court of Session. I learned this via a Freedom of Information request. They are also then denied the right to appeal to the Supreme Court, which, according to the European Court of Human Rights, is deemed to be the highest court of the land, i.e. United Kingdom. See Frequently Asked Questions 26 at echr.com. where it states that you must have taken your case to the highest court of the land, so you can then apply to the European Court of Human Rights to put your case to them. The fact is that you've been denied your human rights, which in this case is Article 6, Inequality of Arms. Everyone deserves a fair hearing. We should be on the same playing field and not the haves and have not of society. Party litigants lose their right to appeal because of paragraph 1.8, where it states that 2 Scottish counsel must sign their appeal. Well, here all party litigants will experience the fact that they cannot approach Scottish counsel, not in their chambers, not at the Court of Session, and certainly not at the Advocates' Library. The only way to approach counsel is via a solicitor. This is where an even larger difficulty lies. A solicitor is then put into a position where he or she only has 42 days to read a case, which might have gone on for many, many years. Then speak to 2 counsel and have them read the case, print their opinion, and apply for the appeal to the Supreme Court. Whilst in theory this would hopefully happen, in practice it cannot and does not happen. First of all, legal aid would have to be applied for, which takes time. Then if it was granted, the solicitor could contact counsel. And if I say, if granted, please take into consideration the cuts in the legal aid. But the real problem is that solicitors are wary of coming into a case at this very late stage. As part of my research, I obtained a list of 38 solicitors via the recommendations of the Law Society of Scotland. Having telephoned all 38 with this scenario, not one of them would be willing to take on a Herculean task. Many stated conflict of interest, lack of funding, too many hurdles to pass, and last but not least of all, the fact that the pursuer of the appeal has been a party litigant, and the legalities of this are a minefield, and not one that a solicitor would like to enter into. It is not the solicitor's fault, but the fault of paragraph 1.8 that denies party litigants their rights. I would also like to add that the Faculty of Advocates, in their response to the consultation of the Courts Reform Bill on paragraph 6 state, and I quote, that they know that party litigants have difficulty in obtaining signatures from counsel. However, it has become increasingly burdensome as the number of cases has been increasing between 2005 and 2010. They received 5 requests in 5 years from party litigants. The definition of burdensome is heavy, onerous, troublesome and hard to deal with. So, as we can deduce, party litigants are not highly thought of by the faculty. I am still waiting for my Freedom of Information request from the faculty as to how many party litigants they have helped to appeal to the Supreme Court. But having contacted the Supreme Court, I already know the answer. Not one party litigant from Scotland has ever been granted the right to appeal to the Supreme Court, and therefore they do not meet the criteria for an appeal to the European Court of Human Rights. Not only does paragraph 1.8 deny a party litigant the right to appeal to the Supreme Court, but also to appeal to the European Court of Human Rights, which is a blatant human rights issue. The theory is there, but as I state, the practicalities deny a party litigant the right of appeal. Everyone must be treated equally with fairness and respect. The current situation contradicts the Act very severely. This is a flaw in Scottish justice. The system in place at the moment is not fit for purpose. It places insurmountable barriers to the party litigant. The same happens in any civil case where civil appeals by party litigants have less rights. The Scottish Government has now clearly recognised there is a problem here. Mr McCaskill, I believe, has mentioned this in the Court Reform Bill, but nowhere are the two words party litigant, and therefore I believe that my petition could only serve to support any further planned measures to bring relief to such cases. Therefore, I feel it is the interest of justice and of all party litigants that my petition is looked at by yourselves.
Thank you very much. And when we're asking questions, obviously I encourage Mr McLean wants to ask any questions. Well, please just catch my eye and we'll be happy to take you in. I think you probably covered my first question, but just for the record, the two-council rule which you mentioned, which seems to be crucial to this, are you arguing then that this is a breach of Article 6 of the CHR, which has the right to a fair hearing?
I'm saying that a party litigant does not have the right to approach counsel, which is a breach of the Inequality of Arms, Article 6. So it is a breach of your human rights, because a party litigant cannot directly go to counsel. They must go via a solicitor.
Thank you for that. And the second question I have is about, obviously, future legislation. Obviously, the Courts Reform Bill, you did make some hints on that, is being proposed by government and will be going through Justice Committee and so on. You know, my understanding of this, then, that would take away the two-council role and would really be a matter for the Inner House to decide whether there's grounds to go eventually to the Supreme Court. What's your view on that assessment of that? Would that, if this legislation went through, would this solve your problem?
No, right. No, it wouldn't, because it doesn't say anywhere. I believe it was put in on the 6th of February, but it doesn't say anywhere about party litigants. It doesn't include party litigants at all. And I think that is a gross problem. The two words party litigants are not in the Reform Bill, and is this going to be a big umbrella and everyone's going to be under it, or is this going to be for people that are legally represented? And that's the problem. If you're not legally represented, how can you go to the Inner House?
Right.
Which is what is proposed. Right.
So you're arguing then that this new legislation wouldn't solve your problem?
It wouldn't cover party litigants at all. Right.
Okay, thank you for that. I'll start with Chick Brody.
Yes, if I may just follow on. First of all, Convener, I get, we've had several of these, and this is a general point, and perhaps not just for the Petitions Committee. I get very concerned about trying to get information out of the legal system in Scotland. And when I look at the approaches that have been made with hardly any replies, then I just wonder what on earth is going on and how our legal system is being administered. People at least have the decency, or should have the decency, of a reply, whether that's from the Lord President, the Cabinet Secretary, or what have you. I'll make that point and I'll leave it lying there. I wonder if we can, good morning by the way, just ask about the change in terms of how you foresee the ability as proposed to approach the Faculty of Advocates as opposed to having two solicitors approve the appeal to the Inner House.
What it is that at the moment, a party litigant would have to get 2 signatures from Scottish Council. And that's where the problem is. You can't approach council. You can't speak to them. You can't go to the Court of Session and speak to them. You can't phone them up. They will have nothing to do with you whatsoever. You must go to a solicitor who will then go on your behalf to the council.
Sorry to interrupt, just stop you there. In the petition, you say that only a solicitor, and in fact only a solicitor practising in Edinburgh.
Yes, that's another problem.
Where's the evidence for that?
I think there is actually a solicitor from Glasgow who has also put a petition in quite a few months ago, I believe, where they laid a problem that a Glasgow solicitor has to instruct an Edinburgh solicitor to be able to go to the Court of Session. That's my understanding, and that's the way it was explained to me. I did go to a Glasgow solicitor who actually told me that. Unless they have the, I think you call it the right of audience to do that themselves.
I find that, if that is the case,
yes,
most disconcerting. Just one last question. I don't want to go, we can't go into your particular detail, but clearly I'd like to ask you, do you agree that there has to be some filtering out of the number of cases that might approach the Inner House? Have you any, other than the two solicitor rule, have you any idea how that might be improved? Or that might be performed?
At the moment, because we don't know how long it will take for the court reform bill to go through. So at the moment, if it could be changed that a party litigant who has gone through the Court of Session, who has appealed and lost their appeal, would then have the right to directly go to counsel. It might be argued that there is a thing called the FLSU, which is the Free Legal Services Unit. You can go to various agencies and ask them to make an application to the Free Legal Services Unit, which is run by certain advocates. It's like a pro bono thing. But they are only allowed to give you 3 days. In many, many cases that have taken years to go through the Court of Session, 3 days is not enough. It takes more than 3 days to read the case, more than 3 days to do research. And so that part, which could be argued about the Free Legal Service Unit, actually doesn't cover a party litigant.
Okay, thank you.
Thank you, Mr. Brody. Other colleagues wish to raise questions or points? Angus MacDonald.
Yes, thanks, Convener. I'd just like to say that I appreciate the petitioner bringing these anomalies to the Parliament's attention. It does seem to me to be unfair that party litigants can only approach counsel through a solicitor, which kind of defeats the purpose and the right of an individual to represent themselves. I also have to agree with the petitioner that the 42-day period for filing a notice of appeal does seem excessively short, and you didn't really touch on that in your preamble. However, it has been noted that the Court Reform Bill does seek to introduce leave to appeal rather than a requirement for two counsel to certify appeals. However, it's my understanding that there doesn't seem to be any intention in the bill to increase the 42-day period for filing a notice of appeal. However, I could be wrong. And clearly, you would wish to see that period increased.
Yes, I would.
Yeah.
If possible.
Yeah. Okay. Okay. Thanks, Convener.
Do any other members wish to have a point? I had just a couple of points that we, as you probably know, we get a briefing from our information service for every single petition. There was 2 points that I just wanted to raise with you. And what Spice are telling us is that, and I'll just quote this if I may, that the treatment of civil appeals from the Court of Session, the Faculty of Advocates suggests that party litigants can approach the faculty direct for assistance in this regard. Do you have any comments on that quote?
I have tried myself, and I know of 3 other party litigants who have also tried to address the Faculty of Advocates. They do not reply. I have a Freedom of Information request at the moment, which was sent 8 weeks ago, and I haven't had a reply for this same thing. The Faculty of Advocates find, as they say in their consultation, they find party litigants burdensome. They have said that, I have it in print. They find us burdensome. That is shocking. That is not being on the same playing field.
Sure.
Everyone having the right.
So
it doesn't work.
Is it reasonable to say then there's still an outstanding issue around the Faculty of Advocates? Because if what we are picking up is they're offering to provide some help and advice, but you're saying that you found it difficult to get a response.
They don't. Okay. This is where the Free Legal Services Unit comes in, which the Faculty of Advocates run for pro bono. But you have the problem there where you have to find an agency, which could be Strathclyde Law Clinic, it could be Citizens Advice Bureau. They will make the application to the Free Legal Services Unit at the Advocates Library, and then somebody will read it and say yes or no. But you only can have 3 days. So perhaps they take 1 day to read it, 1 day to do a bit of research. So when are they going to stand in court and do the proof for you? There is no time. And I hate to say this, but I feel the Faculty of Advocates are it's just window dressing. They don't address the problem. They don't come back with freedom of information. I made a freedom of information request to the Supreme Court in London, and they told me not one party litigant from Scotland has ever been able to appeal. Not one. Why?
The other issue I would just like to raise as well is that the general comments that we're getting through our information, and I'm not putting words in the mouth of our information service, is that advocates won't sign, or the 2 councils that we referred to won't sign unless there's an issue in law that they feel is valid to go to the next stage. That's the general legal... I mean, would you first of all accept that is the summary of where we are in the law?
Well, a party litigant, the majority of party litigants, the average time that they've been a party litigant is 11 years. And I think that they would have a point in law because they wouldn't have kept going for over 11 years. And their cases would have been thrown out of the court. So on the points of law, it is up to the party litigant to put forward the points of law to the advocate. And that's not done lightly. But you're not paying. Yeah. You're not paying for that advocate for the council. Right. And I think money really speaks.
Ms McLean, do you have anything to add at this point?
No.
Right.
Might I add something?
Sure, certainly.
When I approached Lord Gill, he simply sent a letter from his secretary telling me to go to www.supremecourt.com. I didn't ask for legal advice. I didn't ask any unusual questions. I just asked about paragraph 1.8, and he wouldn't answer me. And everybody I've asked in the legal system has told me to go to paragraph 1.8.
Well, thank you for that. Our next step, and we wish you to stay in for this section, but we've come to the end of the questions, is looking how we deal with your petition. Clearly, you've raised a lot of very interesting points and a real frustration from party litigants, particularly getting to the Supreme Court and using ECHR. I mean, the key for us, normally as a committee, we would obviously want to go as far as we can with each petition. There are some exceptions, and that's where another committee is looking at relevant legislation. And as you know, the Justice Committee is looking at the issue of the Courts Reform Bill. So in normal circumstances, and I think this would fit into that, it would make a lot of sense for us to refer the petition to the committee that's actually doing the active work, which is looking at, does this new legislation help you or not? And so my advice to the committee is that we would actually refer this petition as soon as possible to Justice Committee so they can look at the, as long as the merits of the bill, they can look at the issues raised by the petitioner, which I think raises quite a lot of questions, and I would be pleased if our colleagues in Justice could have a look at that. But clearly it's a matter for the whole committee. Can I first of all ask the committee of their views?
I agree, Convener. However, sometimes we forget, and the extension of us forget, why we're here. And that is to respond to people who have genuine issues. I fail to understand why those that be are not responding, at least with some degree of courtesy. And from a personal point of view, I find that wholly unacceptable that information is not being provided, or even the courtesy of a letter. So I hope the message goes from here, whether we do it formally or not, that we're here to represent whether the right petitioners are right or wrong, and they should be treated with that courtesy, no matter where it is in government. And clearly, some of the answers, or no answers, that have been received in this case, frankly, in my opinion, are wholly unacceptable.
I think Mr Brody makes an excellent point. Other colleagues? Do members of the committee agree with the recommendation that we move to refer this to the Justice Committee? Are any other further points that we need to make a note of at this stage? So as you can hear, we're obviously very keen to make sure that the committee who's got this active focus on this legislation looks at not just the legislation but your petition as well. So we'll make arrangements for this to be transferred immediately to Justice Committee, and they will obviously keep you up to date with the petition. So the petition is still active within the Scottish Parliament. It's just going to the appropriate committee that's considering the legislation.
That's something.
Sure.
I did go to my MSP, which is Michael Russell, who informed me that he had spoken to Kenny McCaskill, and Kenny McCaskill said that when Scotland gets independence, they will change the law.
Right.
I just wanted that.
That's slightly beyond my pay grade, but
exactly, yes.
Mr Russell's very entitled to his comments. But as far as what we can do within the Petitions Committee, I do think you've raised Mr Carlow.
Was this communicated to you in writing?
Well, my husband was there. We had.
Do you have it written confirmation?
Oh, no. No.
I think it would be very interesting if you were able to obtain that commitment in writing and share it with the committee.
Right. So thank you, Mr Carlow. So we are. This petition is still active. It's going to Justice Committee, and our colleagues in Justice will take on board the consideration of the bill and your petition. Thank you for raising that with us. You've raised some very worrying points there, and I hope that the Justice Committee are able to look at this in a lot of detail. Thank you for coming along and giving evidence, and I'll suspend for 1 minute to allow our witnesses to leave.
Thanks very much. Thank you very much for listening to us. Thank you.